The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello, I'm Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice, and welcome to Short Circuit, your podcast on the federal courts of appeals, plus sometimes other courts of appeals, those among the several states. This week, we'll be discussing some recent opinions from the Commonwealth of Pennsylvania. Why the Keystone State? Because next week on Friday, October 16th, the Center for Judicial Engagement is hosting an online forum on judicial engagement and the Pennsylvania Constitution. If you're interested, please click on the link that we'll include in the feed for this podcast, or simply go to ij.org/event, singular, EVENT, and then click on the link for the forum at the bottom of the page. At the event, there will be a lot to see, including 2 hours of free CLE for those of you who are members of the Pennsylvania Bar. You can watch a keynote address by the Dean of Law Blogging, Howard Bashman, who in his day job is a Pennsylvania appellate lawyer, as many of you know. There also will be 2 panels, one with IJ's own Andrew Ward, joined by 2 of the foremost experts on state constitutional law in the country, Bob Williams of Rutgers Law School and Seth Kramer of the University of Pennsylvania. That will be moderated by Darpana Seth, our old colleague at IJ, who's now Director of Litigation at FIRE, the Foundation for Individual Rights in Education, which is in Philadelphia. Then in a panel moderated by U.S. District Judge for the Eastern District of Pennsylvania, Joshua Wilson, who is also in Pennsylvania, you'll hear from 3 all-star Pennsylvania litigators. Mark Aronchik of Hangley Aronchik, who is currently actively litigating election law cases in Pennsylvania. Isn't there some election stuff going on in Pennsylvania right now? John Hare of Marshall Dennehy, and has written a book on the Pennsylvania Supreme Court. And David Osborne, who for many years litigated at the Fairness Center in Harrisburg. Unsurprisingly, with all of these experts, we're offering our free CLE. The event is co-sponsored with our friends at the Philadelphia chapter of the Federalist Society, and if you want to sign up through their webpage, you can find it on the main Federalist Society events page. To get us ready for all things Pennsylvania and judicial engagement, this week I'm joined by our fellow at the Center for Judicial Engagement, Adam Shelton, and Josh Wyndham, IJ attorney and lead attorney in Ladd versus Real Estate Commission, a big case from the Pennsylvania Supreme Court from this past May. Now, we haven't talked about that opinion yet on Short Circuit, so I thought it was a good chance to catch up with Josh, ask him what it means for the Pennsylvania Constitution and state constitutional law more generally. Josh, take it away.
Well, I mean, let me start by saying that it's a very good thing for the Pennsylvania Constitution and for state constitutional law. This is an as-applied challenge to an occupational licensing law in Pennsylvania, which apparently had never happened before in the history of the Pennsylvania Supreme Court. We brought a challenge on behalf of a woman named Sally Ladd, who is a vacation property manager in the Pocono Mountains. She actually lives in New Jersey, but what she does is she helps people who own vacation properties in the mountains post and coordinate their short-term rentals on sites like Airbnb, VRBO, that kind of thing. And she was doing this pretty successfully for a few years for friends and neighbors. I think she had a maximum of like 5 or 6 clients at the height of her business. And this to her was a really sort of ideal source of supplemental income. She's in her 60s. She was thinking about retirement. And she thought to herself, this would be a great job that I could do, from my kitchen in my PJs into my golden years. And so she was getting really excited about building up this business. That dream sort of came crashing down in early 2017 when she got a call from an investigator in Pennsylvania from the state's Bureau of Professional and Occupational Affairs, accusing her of the unlicensed practice of real estate. And Sally was pretty shocked. I mean, her conception of what a real estate broker does is that they buy and sell houses, lease out big commercial properties worth millions of dollars. She's like, I don't really do this kind of work. Why would I need a broker's license? And so she started looking into it. And it turns out that the Real Estate Licensing and Registration Act in Pennsylvania, whose original version was drafted in 1929, so about 100 years ago, sweeps in anybody who helps to facilitate the rental of property. Now, obviously, the short-term rental economy, home sharing, Airbnb, None of that could have been conceived by the people who drafted this law in the 1920s, right? And it couldn't have even been conceived by the folks who recodified it and readopted it in the 80s. And yet here we are, in the 21st century with a woman who basically just does all of her work online, being told you have to get a traditional broker's license. And the requirements of this license were pretty onerous. I mean, you have to spend 3 years apprenticing for a licensed broker. You have to take hundreds of hours of courses on real estate practice, 2 exams on real estate practice, and you have to open a separate brick and mortar office in Pennsylvania. She doesn't live there. She doesn't use an office. She works from home. So all of this to Sally seemed incredibly excessive for the work she was doing. And rather than, subjecting herself to all that, spending 3 years in her 60s learning about work she would never do, she decided to shutter her business. And soon after, she found us, and we filed a constitutional challenge to the application of this real estate license to her.
And so the Pennsylvania Supreme Court ruled, but it kind of addressed the merits of the case, but it wasn't actually at the merits stage. Could you tell me where the case is at now and then what the court said?
Yeah. Soon after Sally found us, we filed a declaratory judgments action in the Commonwealth Court's original jurisdiction. The Commonwealth Court is an appellate court in Pennsylvania that can hear constitutional challenges in its original jurisdiction. So that's where we went. Soon after, the government filed a motion to dismiss, what's called a demur in Pennsylvania. And that's basically saying, look, you failed to state a constitutional claim. And, excuse me, and the Commonwealth Court dismissed. They said, look, this law serves a generally valid purpose. The purpose is protecting people from fraud when they're dealing with people who buy and sell property, a large-scale real estate transaction, someone's biggest investment. And that's an important, it's a legitimate state interest in this law. Even if it has an oppressive application to your client, this law generally is rational and related to a legitimate purpose. And we appealed because, one, that's not quite how the test works in Pennsylvania for this kind of constitutional challenge. And two, the courts seemed to fail to recognize that we were bringing an as-applied challenge. They sort of conducted a facial analysis of our constitutional claim. So we went up to the Pennsylvania Supreme Court, and the court reversed the grant of the demur. So we're now past the pleading stage, and we're in the midst of discovery. But what makes the Pennsylvania Supreme Court's decision so remarkable is that it recognized, look, we're deciding a question of first impression, and we're going to re-embrace our heightened rational basis test, our more engaged rational basis test for challenges to occupational licensing laws like this one. And we can unpack that a bit, but one thing what's really wonderful about the opinion is that listeners to Short Circuit might have heard folks talk about the Patel case before, the Texas Supreme Court's decision in 2015 striking down an oppressive application of a cosmetology license to eyebrow threaders under that state's constitution. And the Pennsylvania Supreme Court expressly followed Patel and said, look, we're going to, like the Texas Supreme Court, we apply a more engaged test under our state constitution, one that considers not just rational relationship, but what the court calls a real and substantial relationship between the law and its purported end, and considers whether the law has an unduly oppressive application to the challenger. And those two parts of the test were crucial to the court's analysis and decision to reverse the Commonwealth Court.
What really struck me as, fascinating about this case in general, and then just the Supreme Court's decision here, was, again, as they looked at their own constitution, which doesn't seem like it should be that big of a deal, but it is in state court litigation. People frequently forget that their own state constitutions protect their individual rights. And state courts generally just look to the federal constitution, look at kind of analogous provisions in the federal constitution and in the amendments, and follow what the federal courts have done. But Pennsylvania here said, no, we have our own constitution. We have our own, in Pennsylvania, they call it a Declaration of Rights. And what's really fascinating about the Pennsylvania case is their constitutional history actually predates the U.S.'s constitutional history. Pennsylvania's first constitution was adopted after the U.S. adopted their constitution, or before the U.S. adopted their constitution. And it quickly adopted, subsequent versions, but a lot of their Declaration of Rights remains the exact same as it was before the U.S. Constitution. And the other interesting thing just about kind of state constitutions in general, which Pennsylvania highlights is that under the U.S. Constitution, the Bill of Rights and the amendments protecting individual rights were almost an afterthought. They were a compromise between the Federalists and people that were a little bit more wary of a federal constitution and kind of giving all these new powers to a federal government. But in Pennsylvania and other states, the Declaration of Rights is central to their constitutional process. The Declaration of Rights is first in the Pennsylvania Constitution. It makes up Article 1. It's the very first thing you read when you read the Pennsylvania Constitution, as opposed to the U.S. Constitution, where you have all the different powers of government, the structure of government, and then you get to the Bill of Rights afterwards.
Josh, what's the current lay of the land on different states having, an explicitly more protective rational basis test? I mean, we've litigated at IJ the case in Texas you talked about. Pennsylvania has clarified that, yeah, we really do have a higher rational basis test. Where else are there bright spots and not so bright spots?
Well, I think there's a potential for bright spots, certainly in states with older constitutions, and also in some Midwestern states. Those are the kinds of ones that I can tell you that North Carolina has some cases indicating that the state constitution's substantive due process analysis, its law of the land clause, is more engaged than the federal constitution's test. North Carolina also has some interesting constitutional provisions, like a fruits of your labor clause, that actually trigger strict scrutiny for the right to earn a living, which is really fascinating. It's a new development in state constitutional law down in North Carolina, really worth following. I would say states to kind of be disappointed about, but not necessarily to fully abandon, in our effort to kind of continue to get states to engage with their constitutions are, unfortunately, Maryland, which does have an older constitution, which does have a law of land clause, just like North Carolina, recently decided to forsake a lot of its older case law, applying a real and substantial test. In the 70s, the Maryland Court of Appeals, which is the Maryland High Court, actually expressly recognized that their test was identical to Pennsylvania's test. And Pennsylvania has applied this two-part real and substantial and unduly oppressive test for almost 90 years. At one point, Maryland said, we follow that test. And it has since gone back on that. In the case IJ actually litigated Pizza de Joey, which was a challenge to the city of Baltimore's 300-foot rule. And the 300-foot rule basically said a food truck cannot sell the same kind of food as a restaurant within 300 feet of that restaurant in the city. And the High Court recently just said, look, we apply the rational basis test. We don't apply real and substantial review. And this law satisfies that deferential standard. So you've got states, interestingly, actually, in the Maryland High Court, the court dropped a footnote expressly distinguishing the Ladd case. It was decided a few months after Ladd and said, look, the dissent noted that Ladd seems to follow the Lochner mold, and we're choosing not to go down that sordid path. It seems like
specter of Lochner.
Exactly. So there is a division that's kind of burgeoning between different states. One more thing to note: New Hampshire. I was looking at this yesterday, actually. In 2006, clarified that their real and substantial jurisprudence no longer controls under the state constitution's kind of substantive due process analysis. They just follow the federal rational basis test now as well. So, states are kind of dividing on this, more so recently, I think, given that institutions like IJ are putting this issue directly before the courts and asking them to pick and choose. We did that in Texas. We did it in Pennsylvania. We did it in Maryland. And sometimes they choose wrong and sometimes they choose right. But I would say this, it's a positive trend, right? Like, you have states talking about their own constitutions, having to decide these questions, and that's a really good thing.
And one extreme example of that is, I think probably the worst of all, is the Washington Supreme Court, which, right, in opinion about a year ago, I think that the Pacific Legal litigated, they expressly overruled pages and pages of state constitutional law cases that had applied something different than the extreme federal rational basis test, and said we're washing our hands of those kinds of individual rights protections.
I mean, they attached an appendix that was basically just said everything in this appendix goes away.
Yeah, right. I don't think I've seen a state Supreme Court attach just like a multiple page appendix of like, here's all these cases that are no longer good law.
But a place where prior precedent and the actual text of the Constitution still matters, of course, is Pennsylvania. And so Adam's going to talk about a couple other examples of what the Pennsylvania Supreme Court's been doing recently. Adam, what have you been reading?
Thanks, Anthony. So a recent case that's quite interesting. It's going to have potential huge effects for this upcoming election is an election law case out of Pennsylvania. There, a few Democrats in the state challenged a 2019 provision, which allowed for wider use of mail-in ballots. So in Pennsylvania beforehand, to get a mail-in ballot, you had to prove that you were going to be absent from the state or the district on election day. The 2019 law allowed for mail-in ballots, whether you're going to be absent or not, you didn't have to prove that anymore, which, turned out to be quite prescient because the law was passed in October 2019 before the COVID-19 pandemic. So it actually is quite helpful. But with the issues with the Democratic primary there back in June, there were some issues and some questions about whether or not the U.S. Postal Service would be able to deliver the ballots to citizens in time for citizens to be able to return their ballots by 8 p.m. on election day. So the court looked at a bunch of different evidence about what the general master of the Postal Service had said, and they determined that because of the deadline of when people had to apply for a mail-in ballot, and by the time they might get the mail-in ballot might only be the day before the election, which would not then reasonably give them time to mail their ballot back to the election headquarters, wherever the ballot was going, by 8 p.m. on election night, which is when, under the law, all the ballots had to be received by. So the Pennsylvania Supreme Court kind of split the baby. The petitioners were asking for that deadline to be extended a week out, which was the deadline for the overseas ballots. But the Pennsylvania Supreme Court determined that as long as the ballots are received within 3 days of the election, and they're not. And there's no evidence that they were postmarked after 8 p.m. on election day, those ballots would count. So this case is now, there's a stay pending before the U.S. Supreme Court. Justice Alito requested a response from the Democrats of the state by October 5th. So now we're just kind of waiting to see what the Supreme Court's going to do, if that process is going to remain in place, or whether you'll have to, in Pennsylvania, make sure your ballots are returned to election headquarters by 8 p.m. on election day. But then there's a much more interesting case about the Pennsylvania state constitution from this past July, dealing with COVID restrictions, but it's not an individual rights challenge like many COVID-related restrictions have been. This case actually pits the Republican General Assembly against the Democrat governor over the Democrat governor's emergency declarations relating to the COVID-19 pandemic. So under the Pennsylvania Emergency Code statute, the governor can declare an emergency for up to 90 days, which gives him a whole host of other powers, which allows kind of money to move around, and which allows kind of the suspension of certain restrictions. And it was under this power that the governor actually closed a bunch of different businesses that were not considered to be life-sustaining. A few of you might actually remember that. We talked about that case, Friends of Danny DeVito, on a previous Short Circuit episode.
A different Danny DeVito.
Right, not the Danny DeVito that you're thinking of, most likely. And the Supreme Court actually just rejected cert in that case this past Monday. So it gives the governor a wide amount of powers, but it caps the emergency declaration at 90 days unless it's renewed by the governor. So the governor issued his original emergency declaration. He then renewed it. A couple days after he renewed it, the General Assembly passed a concurrent resolution to terminate his emergency order. So the statute that gives the governor the power also states, I'm going to quote here because the language here is actually very important, that the General Assembly, by concurrent resolution, may terminate a state of disaster, of emergency at any time. Thereupon, the governor shall issue an executive order or proclamation ending the state of disaster emergency. So the General Assembly passed this concurrent resolution, but the governor said he wasn't going to follow it. So they filed a lawsuit, and it started in the Pennsylvania Supreme Court, with their King's Bench jurisdiction, which allows them to kind of take over a case from the very beginning. And the governor was arguing that this statute and this clause actually ran against Article 3, Section 9 of the Pennsylvania Constitution, which is their presentment clause, which requires every order, resolution, or vote to which the concurrence of both houses may be necessary, except on questions of adjournment, be presented to the governor for signature or veto, and then the General Assembly can override that veto if they have the votes. So the question all really comes down to, does the presentment clause in the Pennsylvania Constitution restrict how the statute is supposed to operate? The majority here in this case decided to employ what is known as the canon of constitutional avoidance and interpret the statute to not require presentment or to require presentment. It said that if the General Assembly had envisioned a case or envisioned a situation where presentment would not be required, they wouldn't have put any burden on the governor to then issue an executive order or proclamation ending the state of disaster. I think that's a bit of a kind of tenuous reasoning there to interpret the statute to say, well, presentment isn't foreclosed under the statute, and so they interpreted the statute in a way to require presentment to avoid deciding the constitutional issue at question, which is whether or not the statute violated the presentment clause. The court also looked to the Pennsylvania Declaration of Rights, in this case, Article 1, Section 12, which says that no power of suspending law shall be exercised unless by the legislature or by its authority. The legislature argued that because of this protection, that they had the power to act unilaterally without presentment to end the emergency order, because that's part of the emergency order allows the governor to suspend laws and allows the executive agencies to suspend the operation of laws. The court again rejected this statement here, rejected this argument, saying that there was no actual affirmative power given to the legislature by this. What's interesting here, which I think is kind of more of the way the court should look at this, was in the concurrence and dissent by Justice Doherty, which actually brings up some very interesting questions that will be before the Supreme Court, the U.S. Supreme Court this year, regarding severability. So there, Justice Doherty argued that there is no other way to read the statute than to not require presentment, that the statute doesn't require presentment at all. So since the statute doesn't require presentment, and since this is an essential legislative activity, that provision of the statute is unconstitutional, which then gets us into the question of whether or not that provision of the statute is severable from the rest of the statute. Because it is such an important safeguard and allows the legislature to kind of manage emergency situations in a way they wouldn't otherwise be able to, he said that that it's not severable, and that the whole statute, the whole emergency management statute, should fall as unconstitutional.
This is an interesting case for a number of reasons, Adam, and you covered a lot of them in kind of a shotgun approach, which I appreciate because there's a lot being addressed in this case. One thing I found fascinating, since we were just talking about Ladd, was, and I don't know if I mentioned this, but the dissenting justice in Ladd was Justice Wecht. And Justice Wecht was the one who wrote the majority opinion in this case. And it's kind of interesting to see, I mean, the threads in his decisions are very, very consistent. So in the dissent in Ladd, he accused the majority of basically legislating, of saying, look, you're considering whether this law is rational, arbitrary, oppressive. These are things that the legislature as a political branch typically weighs when it's making policy. And so that's what the majority is doing here. It's creating policy, it's legislating. In his majority opinion in this case, Adam, he starts and ends his opinion by making very, very clear what the court was not doing and how narrow the questions in the case actually were. He starts by assuring everybody that, look, this is a dispute between the political branches about an issue of policy that reasonable people can disagree about and that people have strong opinions on. And we're not taking a position on any of that. We don't weigh rationality. We don't weigh oppressiveness. We don't do any of that. This is just a question of whether the law is constitutional or not. And the Constitution has nothing to do with those concepts. And then he ends his opinion by saying, look, we've decided these narrow questions. We understand this is a politically charged issue. We don't weigh into policy. We don't weigh into politics. We're just kind of we're on the straight and narrow in our analysis of these things. It's just interesting how he frames that because, you mentioned the Danny DeVito case. In the majority there, I think it was Justice Donahue who wrote that opinion. She said, look, part of what we're going to analyze here, and whether this is a proper exercise of the police power, this executive order, is oppressiveness. We're actually going to go through this analysis. And he joined that opinion. So I'm kind of interested in whether these two opinions, DeVito and this one, can actually be reconciled on some of these points. Now, it may be dicta. Honestly, I think it's kind of unnecessary for Justice Weck to be making these introductory and concluding statements about deference and the limited role of the court to reach the merits of these questions. But I find it fascinating that he maintains the level of consistency that he does. I mean, you have to give that to him.
Yeah, you definitely do. And I think, this opinion is super fascinating. And I think that the concurring and dissenting opinions kind of get more to the point of, it seems like the majority is trying to find a way around the constitutional issue. And they say they're trying to find a way around the constitutional issue. And they almost rewrite the statute to do that. There's nothing in the statute to require presentment. They kind of base their whole argument on, well, the statute requires the governor to do something, so it must be that it must then be presented to him. But it seems very tenuous, the connection between requiring the governor to issue an executive order declaring the emergency over, while giving the governor the power to veto that concurrent resolution. As one of the amici pointed out, kind of the court's decision here gives the governor kind of unchecked power. He can continue to extend this emergency as long as he wants to. And the General Assembly can't do anything about it unless they have a veto-proof majority to override it. And what's actually interesting is that technically it takes less votes to impeach the governor than it does to override the governor's veto. So so it's this interesting situation where the governor can continue extending this emergency power until the General Assembly has enough to override his veto. But once they have enough to override his veto, they could simply just impeach him for if they think he's abusing abusing the emergency power. So it's like a very interesting situation here.
What majority do they need to impeach him, by the way?
Well, I think it's 2/3 in the Senate and then just a majority in the House. So it becomes like a very interesting question as far as like, well, at what point does the emergency power and the continual extension of 90-day emergencies become too politically untenuous, I guess, for the General Assembly? So I mean that delves into very political questions versus the constitutional questions. And I think the constitutional questions are just much more interesting because you have just like this presentment language that very clearly says, bills should be presented. And I think the statute clearly envisions that it shouldn't be presented.
Well, one thing I thought was telling is, although they do, make it a constitutional avoidance statutory construction case, they do pretty much outright come and say that a legislative veto, which is pretty much what the statute envisions, would be unconstitutional. And they rely on a case many listeners probably remember from law school, Chadha, about a legislative veto that the Congress used to have in regarding some immigration matters, and that actually was used in a lot of statutes until Chadha. The U.S. Supreme Court said, nope, you can't do legislative vetoes. It has to be presented. Although I think a good thing that the Pennsylvania Supreme Court did here was they relied on, though they looked at Chadha, they also relied on the text and history of the Pennsylvania Constitution in a big way. Which, by the way, a little segue here, but the Michigan Supreme Court had a big case last week that many of you might have heard about the non-delegation doctrine in Michigan, and found that the governor's orders there were unconstitutional under the Michigan Constitution. And they received some criticism because they relied mostly on U.S. Supreme Court decisions, not Michigan law and the structure of the Michigan Constitution, which I think was last adopted in 1963 or 62. And so what's interesting here is, the Pennsylvania Supreme Court really took its time looking into its own case law and history, but it came out at the same way the U.S. Supreme Court has come out in the Chadha case and said, although it's still just statutory interpretation, a legislative veto is unconstitutional. It says one line of the opinion, A legislative veto in the context of a statute declaring emergency powers might be a good idea. It might be a bad idea, but is not a constitutional idea under the current charter, which kind of gives the writing on the wall, right, for if that was true in other contexts.
Right. And I think kind of going back to the structure of the decision, like you pointed out, the Pennsylvania Supreme Court relied on kind of Pennsylvania cases. They cited a lot of Pennsylvania cases, and they actually relied on other state constitutions. So in their decision, like they quote from, I think, the Kentucky Constitution and the Louisiana Constitution and quote analogous provisions from there. And they really seem like they're trying to figure out what the Pennsylvania Constitution says and how the Pennsylvania Constitution directs them to approach the situation and resolve the situation, which is very different, again, from like the Michigan decision, which focused very much on federal law.
You have to wonder. I mean, I certainly wondered this when I was reading through these cases, and I'm aware of the Michigan case too, and I wonder whether the different results in these cases is a function of when they came down the pipeline in the COVID crisis. Because I mean, if you think about this case, the Scarnetti, is that how you say it?
I think so.
Yeah. If you think about this case, I mean, it comes on the heels of the Danny DeVito case, where the court issued very broad statements about the deference paid to the governor in time of crisis, the broad powers delegated by the Emergency Act, the broad, basically how this is addressing a pandemic and a crisis like this is the sine qua non of the police power, right? These are just, how do you follow up a decision like that by paring back any of that? It seems like it's just too proximate to what they just said. And so they cite Danny DeVito a lot in this case to kind of justify various aspects of the opinion. And so to me, I mean, it seems at least plausible that if the Pennsylvania Supreme Court hadn't decided one of the very first cases involving COVID at the state Supreme Court level and come out the way it did, as deferential as it did, we might be talking about a different decision here. That may help to explain a little bit how courts are. I mean, the courts that have addressed this a bit later have taken a bit more of a skeptical stance of some of these executive orders that may be getting stale, right? Or that may at some point warrant a bit more skepticism than initially during the kind of outbreak of the pandemic.
So I definitely think timing has a lot to do with this case here. This case came down in July, just a little more than a month after the first renewal of the governor's emergency declaration. So this is like only the second 90-day period during the time the court was deciding this case. When you think back to July, so much was still unknown and so much still is unknown. So it's very understandable why the majority would be hesitant to come to a conclusion. I think the concurring and dissenting opinion had the best kind of conclusion that the statute violates the presentment language and therefore has to be, or is not severable, because the presentment issue or the concurring resolution that allowed the General Assembly to terminate the emergency was so important to the statute that the whole statute would have to fall. I think the majority was very worried about canceling the entire Pennsylvania emergency code in the middle of the pandemic, especially with, the election coming up, with flu season coming up, with so much unknown. It's very understandable why they'd be very wary and want to really make sure that they exhausted all other options before striking down such an important law.
I think we'll close on something I warned Adam about that will be totally non-controversial and not relevant to what's going on in the country right now. And that's that given what the Pennsylvania Supreme Court has at least hinted, as I was talking about the legislative veto, that you need presentment under the Pennsylvania Constitution at least. There is this clause in Article 2, Section 1 of the U.S. Constitution that we forget about sometimes. So it says,
speak for yourself.
Each state shall appoint in such manner as the legislature thereof may direct a number of electors. And then it goes on about the electors. Now, this, of course, is the language about the Electoral College. And although the Electoral College was reformed with the 12th Amendment, as many of you learned in high school civics, this language still controls for how the states do their electors. And of course, every state has elected by the people their electors for a long time. But there still remains this question of what could the legislature just appoint electors? And some of you may remember, some are of our younger listeners may not, but some of you may remember in the 2000 Bush v. Gore case and the litigation there and the recounts in Florida and all of that, there was this move by the Florida legislature to, because the litigation and recount was taking so long, to just go ahead and appoint George W. Bush's electors as the electors for Florida as the legislature. And that was in accordance also with some old federal legislation, but it was primarily under this this clause. And I think the concurrence by Justice Rehnquist, Chief Justice Rehnquist and Bush v. Gore also talked about this clause and how it says legislature, and it doesn't, say governor and legislature. It doesn't say state. It says legislature. Well, the Pennsylvania Supreme Court has now talked about legislature, of course, with its own constitution. But we have heard, these reports, and I've heard they were overplayed, and this was just, thinking if we had another Bush v. Gore in a really close election. But there is this specter out there about, what if a legislature tried to do something really evil, even if its state went for one candidate, if it was nevertheless select the slate for the other, because it is the legislature after all. And the question arises, if that was in a state with the legislature in one party, but the governor in another, could the governor veto that? Or is it entirely in the legislature's discretion? Of course, this is, the supremacy clause of the Constitution may apply here over the state constitution. So, Adam, I don't want you to take a stand on who would win in that. Neither does anyone on this podcast. But what are your thoughts about how you would even think through how that would work?
Right. So I definitely, it's a fascinating question. And I think that it all comes down to whether or not the appointment of electors would be considered legislation. So part of the decision was a huge discussion about whether or not what the General Assembly did in this case was actually legislating, because presentment is only required when there is some sort of legislative action or when it binds the state or commits the state to some sort of a position. So, for example, the spending of money or the creating of different departments requires presentment. But there's an explicitness in the text that says it doesn't need presentment for questions of adjournment. And when the founders of the Pennsylvania Constitution were, writing this provision, it was all about kind of core legislative purposes. So the question really comes down to whether or not the appointing of electors would be a legislative act, or whether or not. So there's that question there as far as kind of the interpretive question. And then there's the other kind of interesting question of who actually decides this case. Is it the Pennsylvania Supreme Court in their interpretation of the Pennsylvania Constitution? Does the U.S. Supreme Court have to interpret the Pennsylvania Constitution and what the presentment language in the Pennsylvania Constitution means in light of the U.S.'s Constitution's requirements for the appointing of electors and the Supremacy Clause? So there's a whole host of very interesting questions, but it really will come down to whether the appointing of electors was considered as part of the legislative question by the founders and the drafters of the Pennsylvania Constitution. An interesting wrinkle that's kind of thrown in with this is that this language in the Pennsylvania Constitution, the presentment language, is largely unchanged from its second constitution, which was adopted in 1790. The second Pennsylvania Constitution was adopted in Philadelphia. There was another big constitutional convention in Philadelphia just a couple years earlier. So there's a lot of interplay between what the U.S.'s Constitution's presentment requirement is and how that's interpreted with the Pennsylvania Constitution's presentment clause, because they were adopted almost at the same time in the exact same location, really.
This is it. So it's interesting that you gave that answer, Adam, because my first thought was based on, the last thing Anthony said was that it might raise a supremacy clause issue. And so my thought was that would be kind of the dispositive question. So I'm curious why you chose to perform kind of that breakdown based on is it a legislative act or not?
Well, I think I think the supremacy clause is probably going to be the deciding question as far as what can happen. I think the supremacy clause will be important for who gets to decide the case. whether it's the U.S. Supreme Court or the Pennsylvania Supreme Court. But I think it still has an interplay with the Pennsylvania Constitution because the Pennsylvania Supreme Court can just decide that there doesn't need to be presentment. If there doesn't need to be presentment, then there really is no conflict potentially with the U.S. Constitution. But kind of like Anthony was pointing out, what makes this so interesting is you have a split of the governor and the legislature party-wise.
I see, there's an argument here that Article 2, Section 1 of the U.S. Constitution perhaps gives a power to the legislature of every state that perhaps the state constitution or state laws doesn't give to that legislature. What does that even mean? Or do you have to go through the law of the state to figure out what, quote, legislature means in Article 2, Section 1? Like, does it incorporate the state law as to what legislature means and that you can't have legislative vetoes or whatever? Or is it just this independent power that because it is a legislature of a state, it wields without its own state laws, which is hopefully a question we will never, ever have to answer in the United States, let alone in the state of Pennsylvania. But there are many questions about state constitutional law, Pennsylvania law, that will be answered at our forum next week, Friday, October 16th. Please join us. Again, you can find us online in various ways. We'll put a link up on the feed to this podcast. You can also go to the Federalist Society's page for their events because we are co-sponsoring with the Philadelphia chapter of the Federalist Society. Anything you ever wanted to know about the Pennsylvania Constitution, other than the question we just talked about, will be answered at this event. And it will be a way for you to get engaged with the Constitution. So for everyone, thank you for joining us today. We'll see you next Friday, October 16th, with the Pennsylvania State Forum. Thanks, everybody.